Thanks.
Conference on Thursday, February 12, 2026, Section 14.1 of the Lobbying Act and the motion adopted by the committee on Wednesday, September 17, 2025. The committee is resuming the statutory review of the Lobbying Act. And before I introduce our witnesses, as I always do, just to remind them that committee members may ask questions in French and English. And if you do need interpretation, just take a moment to prepare the earpiece and select the listening channel you need in advance in order to take full advantage of the time allotted for questions. And in some cases, there is a bit of a delay in the interpretation, so just wait until the interpreters are finished. I'd like to welcome for our first hour today from the Treasury Board Secretariat, Brian Gear, who is the Executive Director, Policy Planning and Performance Priorities and Planning Sector, and Peter Ross, who is the Director, Policy Planning and Liaison, Priorities and Planning Sector. Welcome to both of you to committee. I believe it was Mr. Gear. You are going to provide the opening statement for up to 5 minutes. Go ahead, sir.
Yes, thank you, Mr. Chair. My colleague Peter Ross
and I are pleased to join the committee to contribute to your statutory review of the Lobbying Act.
Conseil de Trésor suit.
We at Treasury Board Secretariat have been closely following the committee's important and timely work. We welcome the different perspectives and recommendations on the Lobbying Act that have been shared with the committee by the Commissioner of Lobbying, her provincial counterparts, expert witnesses, and stakeholders from the private sector and civil society.
To the mandate of the President of the Treasury Board and the Treasury Board Secretariat. As members know, the President of the Treasury Board is the Minister responsible for the Lobbying Act. That means the President is responsible for bringing forward any amendments to the Act or its regulations on behalf of the government. The Treasury Board Secretariat supports the President in fulfilling these responsibilities. This includes providing policy analysis and advice on any recommendations to update the Act. TBS is not responsible for the day-to-day administration of the Lobbying Act or for providing expert guidance on the Act. The Commissioner of Lobbying is responsible for administering and overseeing compliance with the Lobbying Act. She also has the mandate to interpret the Act and to provide guidance on its application. As such, I am limited in my ability to comment on matters that fall under the mandate of the Commissioner, such as how to comply with the Lobbying Act in certain situations. The Lobbying Act ensures that Canadians know who is lobbying their elected representatives and other government officials and on what topics. The Act works alongside the other parts of the integrity framework, such as the Conflict of Interest Act, to uphold public trust in government decisions. While the Act came into force in 2008, federal lobbying has been regulated since 1989. The purpose of the federal lobbying regime has always been to advance two important public interests: the transparency of lobbying activities on the one hand, and free and open access to government on the other. In this regard, the governing principles set out in the Lobbying Act's preamble affirm that the public has a right to know who is engaged in lobbying activities and that lobbying is a legitimate activity that should not be impeded. That is why the Act's core registration and reporting rules are intended to ensure transparency without creating undue administrative burden. The committee has heard a diverse range of views on how to ensure that the Lobbying Act continues to meet its objectives. TBS is closely examining the recommendations that have been shared by the Commissioner, stakeholders, and experts. The government also looks forward to receiving the committee's report resulting from this review of the Lobbying Act. I would like to thank the committee once again for inviting us here today, and we're happy to take your questions.
Okay, thank you, Mr. Gear. We're going to start off with our first 6-minute round, and we are going to go to Mr. Barrett. Go ahead, sir.
Does the government believe that the current definition of lobbying is adequate based on the activities in the year 2026?
So what I would say about the Lobbying Act is that it is it's a fairly robust framework the way that it has been set up, and there probably is a reason why there has not been significant change made to the legislation since 2008. Obviously, there have been a number of changes with respect to the expectations of Canadians around transparency, around technologies and the use of social media, which certainly would necessitate considering updates that could be made to the Act. But overall, I think that the Lobbying Act, along with the other parts of the integrity framework that are in place, are relatively sound.
What changes is your department and the government making to improve transparency, both on access to information and also on lobbying communications?
Well, I do know that there are consultations that are underway on the Access to Information Act that are being undertaken by another part of the Treasury Board Secretariat right now, and looking to modernize the Act in that respect. In terms of lobbying communications, we are obviously watching very closely the review that's being undertaken by the committee here, and we certainly look forward to any advice in terms of how the Act be modernized.
How does Treasury Board assess compliance and enforcement challenges as the Act currently exists?
So we're not responsible for enforcement of the Act or compliance. We certainly rely on the Commissioner, as the committee has heard, in terms of her take and on how the Act has been enforced to date, and any challenges that she faces in that regard.
And so the assessment or opinion of the Commissioner is accepted wholly by the Minister and by the Department?
No, I would not say that. What I would say is that the Commissioner, obviously, the input that she has provided is extremely valuable, and we certainly value the opinions and information that she has shared in terms of how she sees the administration of the Act. The one thing about the Lobbying Act, obviously, and as I pointed out in my opening statement, is that there are trade-offs to be made in terms of transparency and the access to public office holders and the administrative burden that are caused by it. And obviously there needs to be a decision that is made in terms of what is the appropriate trade-off between those two principles in terms of the right approach.
What gaps do you think exist in the reporting requirements that limit public confidence in this as an effective tool to ensure transparency in government?
Well, I think a lot of the issues that have been raised by the witnesses that have come in front of the committee do indicate that there is the potential for increased transparency in a number of different regards. A lot of the questions about the treatment of lobbyists, in-house versus consulting lobbyists, I think that there are some questions to kind of re-examine there to see whether the rationale that was in place in 2008 when the legislation was originally brought in are still valid in today's world. So again, we certainly would value the advice of the committee and have benefited from hearing the testimony of the witnesses in front of this review to help educate us in terms of what the right approach would be to go forward.
Is the Treasury Board Secretariat of the opinion that the administrative burden on consulting firms and lobbyists that are subject to the Act is now too onerous for them?
What I would say is that obviously administrative burden is a key consideration in terms of what needs to be done, and it's a policy decision ultimately on what the appropriate balance is between transparency and the administrative burden. We are certainly taking note of what different stakeholder groups are saying in terms of the administrative burden that they face, as well as what they anticipate to face if some of the Commissioner's recommendations were to be accepted and implemented.
Has the TBS changed its position on that administrative burden since the last time a review was undertaken?
It's hard for me to comment in terms of what the position was of TBS at the last time of the review. That was 14 years ago now, and so I wasn't in the chair at that time. What I will say is that administrative burden certainly is an important consideration in a lot of the work that the Treasury Board Secretariat is currently undertaking. And obviously, the President of the Treasury Board has been leading a regulatory red tape review, for example, and looking at ways to make things easier for business in a number of different regards. So that's definitely a priority for the department and for the President, and something that we would take into consideration.
Okay, thank you, Mr. Barrett. Madame Lapointe, pour 6 minutes.
Merci beaucoup, Monsieur le Président. Bienvenue.
Thank you, Chair, and welcome. Thank you for being with us today. You're greatly appreciated. Can you explain why there's a distinction between in-house lobbyists and consultant lobbyists, and what the committee should look into in examining whether or not we should have registration by default or whether we should maintain the current format?
Merci pour la question.
For the question. There's a distinction between the in-house lobbyists and their responsibilities towards companies and businesses.
A few regimes in the world that actually includes in-house lobbyists in terms of the lobbying regime. So we actually have gone a lot farther than most regimes where they only look at consultant lobbyists. And the reason why there are some distinctions is because it is hard to, within that whole population of in-house lobbyists, there are a lot of different types of people that fall into that population. For example, we could be talking about small business owners. We could be talking about heads of charitable organizations. Or we could be talking about CEOs of major corporations, right? Major multinational corporations as well. So while one of the beauties of the Lobbying Act is that it has such a broad scope and it's very comprehensive in its reach in terms of capturing both in-house and consultant lobbyists, and there are roughly 9,000 consultants that are currently registered within the current regime, which is very significant, I would say. It's hard to then be able to adopt a one-size-fits-all approach for all lobbyists within that population. So that's why I think that we've adopted the approach that is in the legislation was adopted the way it was. Absolutely, it's time to kind of take a look at it and see how it works and whether there are opportunities for improvement within the current circumstances. But overall, I think that explains the rationale behind the approach that's been part of the legislation.
Merci.
Thank you. Earlier, my colleague mentioned transparency. How can we strengthen transparency with the regime while maintaining an open and efficient dialogue between decision makers and stakeholders?
Merci pour la question.
Thank you for the question. Transparency and access to government officials, these are both very important, and they're at the foundation of the legislation.
I think in terms of some of the recommendations that have been put forward, there are opportunities for increasing transparency there, and that they need to be looked at carefully to understand what all the different considerations and implications would be. What I would say is that, for example, the recommendations that have been put forward by the Commissioner, a lot of them do have effects on each other, and they kind of compound the different impacts that would be hitting the lobbyist population. So we would definitely need to, kind of carefully consider what the cumulative effect of administrative burden would be in terms of moving forward in certain regards if we wanted to try to increase that transparency. The other thing, too, is that we need to be very kind of mindful of what the value of additional measures would be in terms of increasing transparency, and looking at that carefully in terms of, is that information, is the saying in English is, is the juice worth the squeeze? Would the value of that additional information really be worthy of the cost of the implementation and the potential administrative burden for lobbyists?
Merci. À votre avis?
Thank you. What elements from the current regime are working well and should be maintained in the modernization of the Act? That's a good question. You heard from the OECD and were able to discuss their observations regarding Canada's regime.
Very complimentary of the lobbying regime that we do have in place when they were comparing it to other regimes in other jurisdictions. I think overall, like I said, that we do have a fairly robust regime. It is very comprehensive in terms of its scope. And the reporting that is done there, I believe the Commissioner reported roughly about 30,000 communication reports that were filed last year, which again does provide a lot of transparency. So I think that there's a lot that is being accomplished and being very helpful in terms of transparency. But again, there's always opportunities for improvement, and it's very timely for this review to help look at what those opportunities may be.
Merci beaucoup.
Merci, Madame Lapointe.
Thank you, Ms. Lapointe. Mr. Bonnet, welcome to the committee. You have 6 minutes. Thank you, Chair. You talked about the OECD, but when we look at the Commissioner's first recommendation on registration by default for these lobbyists, there are OECD representatives who said to the committee that for countries that don't have registration by default but have different thresholds, well, they have a hard time managing and implementing their policies. They also said that countries like Portugal, they had a new rule in 2025, and they chose to not use a threshold, but to rather have registration by default. And so managing things having a threshold is more complicated than having registration by default. Would that not be a better idea? Would that not simplify things? There are a lot of advantages in having a system that is simpler.
Although I think that there would need to be conditions and thresholds in place. For example, the British Columbia regime talks about how they do registration by default, but even in those cases, the small businesses with employees of less than 6 persons are exempt from the registration requirement. So I think that whether you call it registration by default, I think there are always going to be exceptions and conditions that would need to be put in place so that the system didn't become so burdensome that for the one person who occasionally, and very occasionally, is in contact with a public office holder, needs to actually register in the system and have to take on that additional burden.
Là, vous me donnez un cas très précis, là, mais en général, vous pensez pas que ce
You
serait...
talked about a specific case, but would it not be a good idea to have registration by default because it would simplify things? Do you not believe it would simplify things? That is an option.
One of the things that I think that we're looking at right now and we're learning from is the changes that the Commissioner has actually put in place in terms of the significant part of duties. By reducing that threshold significantly to 8 hours over a 4-week period, I think that that's capturing a lot more lobbying activity, and we're certainly learning from that experience, and that will help educate our view in terms of whether registration by default going in that direction is a good direction.
Ma question, c'est est-ce que ça simplifierait les choses?
But would that simplify the system to have registration by default, in your view?
Approach. I just caution that there are a lot of implementation details that would need to be worked out, and I have difficulty believing that there would be no exceptions or conditions that would need to be put in place in what we would call a registration by default system.
Dans le cadre de l'examen du fardeau...
In looking at red tape and saving and cost savings for government, you mentioned that you would be reviewing registration requirements for the lobbyist registry, and the goal is to reduce the administrative burden for legal entities, organizations that are subject to the Lobbying Act. But in 2012, Mr. Scott Douglas from Treasury Board stated to this committee, or the committee at the time, that registration and managing the registry was not an administrative burden, or not a significant one anyway, for lobbyists. Why do you think that you need to reduce the administrative burden for lobbyists? Thank you for the question.
Necessarily come out and say that the administrative burden is wrong. I think it's just something that, if we're looking at changes, that is certainly an important consideration that we need to take into account about how much administrative burden that we will be placing on the lobbyist community. So as I said, if we were to proceed with amendments to increase transparency around lobbying, that would definitely be something that we would need to consider. One thing that I would say about the regulations themselves is that we did include them in the review, in the red tape review, as something that we would be willing to look at. This committee then announced that it would be looking at doing a statutory review of the Act. So we did put that on hold until we received the input of the committee to do that. But we certainly are keeping an eye on how recommendations come and deciding what the approach would be. And then we would undertake that review again. And one of the things that we'd be looking at is actually how we can make it more nimble, because the regulations that they're currently written are extremely prescriptive. And there's probably ways that we can make it much more nimble and flexible going forward.
45, okay.
45 seconds. The Commissioner believes that her office could manage that all communications be subject to registration, so phone calls, texts that currently aren't subject to the Act. Do you believe that the Commissioner's request would stop any kind of activities that aren't currently being seized that we would be able to see now? Thank you for the question. With technological changes and changes in communication, things are very different now than they used to be.
Came into effect in 2008. Obviously, the texts, the types of communications that we do, social media and other, have changed significantly. So I think that is certainly a question that we should look at, and we would value the input of the committee and others in terms of how that could be modified.
Monsieur Bonnet, second
Thank
round.
you, Mr. Bonnet.
5 minutes. Commencez, s'il vous plaît.
Merci d'être avec nous. Alors,
Thank you for being with us. I listened to your opening remarks. So your Treasury Board is responsible for the legislation. You said this in English, but in French, I'll try to repeat it, that the goal is to improve Canadians' trust in the work that is being done in Parliament and by the institutions, correct? And from 2008 to now, do you believe that people trust their institutions more or less than they used to? Thank you for the question. There are a lot of challenges in maintaining the public's trust for their institutions.
That have led to that.
vous êtes d'accord qu'il y a plus ou moins de confiance?
So
Les gens
do you agree that people don't trust their institutions as much because of these challenges?
Showing public opinion that have shown that confidence in public institutions has declined over time. Again, I'm not sure I would attribute that just to
Non,
the
mais
lobbying
ça
act,
fait
but-
juste dire que votre travail est important parce que vous êtes
Your work is important. You're responsible for something that is there to maintain trust in institutions. You talked about trade-offs earlier, the advantages, the disadvantages, so pressure put on lobbyists for registration, and then the administrative side that would be required to manage all that. Knowing that people are losing trust in our institutions, do you not think then we should focus on rebuilding trust, and so we should be more transparent? Reducing these thresholds might undermine trust further.
would say, again, obviously, I think that expectations of Canadians with respect to transparency have changed, and there have been a number of different changes that have been made over the years in terms of increasing transparency on government information. For example, so obviously, yes, I would say that we should be very cognizant of that, and that should be an important consideration when we're looking at potential changes to the Act. On the other hand, the importance of cost, and the cost on business, and the cost of nonprofit organizations in terms of dealing with red tape, we've also heard that to be a significant concern, and so it's also an important consideration going forward.
Allons sur ce que vous venez de dire là. Donc, en 2012,
In 2012, your department, Treasury Board, stated that lobbyists respect deadlines, there are no issues, and that there is very little administrative burden because of the website that was put in place. And so if your website was improved, and in 2012 it was not a problem, there were no issues with registration, and you said not long ago that it was extremely restrictive. So what happened between 2012 and now that made it go from efficient in 2012, and yet now with the improvements of your website, now it's considered extremely restrictive? What happened?
Je m'excuse s'il y a une...
I may have misspoke.
The cost of the regime right now is too high. What I was just pointing out was that if we were to make changes to the legislation, that we need to be very cognizant of what the changes would be and the impact that would have on the administrative cost. So I think that generally our view is that, and it's probably in line with what we said in 2012, that the current burden is probably appropriate in order to fulfill the provisions as they are now. But I'm very mindful of the recommendations that have been brought forward to the committee by the Commissioner, and that the push for greater transparency in a number of different regards. And I'm just pointing out that in terms of good public policy, it needs to be a consideration of what the appropriate balance would be between transparency and administrative burden.
merci. La commissaire au lobbying a dit ici, en fait.
The lobbying commissioner said to us that there's not enough transparency in the federal regime, and we know that it is important. There were proposals, registration by default, that you register all types of communication, naming all of the in-house lobbyists. We have that in Quebec. And if we want to have that throughout Canada, and we want to increase the threshold and not lower it, why then are you proposing reducing what is required of lobbyists when requirements in the provinces are higher? A quick response, please.
Lower the threshold at all. Again, I'm just pointing out that as we consider any potential changes, and there's a lot of interest in more transparency, that we take the cost into account.
Thank you, Mr. Gear. Merci, Mr. Hardy.
Thank you, Mr. Hardy. Mr. Alsoud.
Okay. Let's switch over. I might have to turn the volume up on this one. Let me double check.
There's more than one device that can access that cloud, for example, and it's in the possession of someone else that's off premise, and they find out about the search before the police may actually be able to seize that evidence going further, or to write a new production order, or a search warrant. What could happen is that other person who has access could delete whatever information would be there. So it's crucial to have access to that information and be able to seize it with judicial authorization, of course.
Okay, and actually that just brings up another question. I have noticed this on my cell phone, for instance, in my contacts. They're all on the cloud now versus actually on my device. So that has changed quite significantly over the most recent years, correct?
Precisely.
Okay, thank you. That answers my question.
Merci, Madame Kirkland. Le député Caputo, s'il vous plaît.
Thank you, Ms. Kirkland. Mr. Caputo, please.
Okay, first off, I'm a total nerd, and especially on this subject. So I'm going to give you one of my real life examples, because I think it's, and just see if this is what I'm getting. What we're talking about here is what is specifically on the system versus what is accessible to the system. Is that accurate? Okay, so one of the first cases of internet luring I dealt with was a very disgusting individual who was luring children from the Philippines.
and he was caught on a breach, or he was actually arrested for more substantive charges. Initially, it was a child sexual abuse material investigation. The RCMP got his hard drive and realized, whoa, he actually was arranging offenses in the Philippines. So he was then arrested on that offense. In the search incidental to arrest, a cell phone was recovered, which was contrary to his conditions on the original charge that he not possess any electronic devices. Then the RCMP did a data extraction with a warrant. Within that data extraction were all sorts of Facebook communications. Am I right to say that those Facebook communications would not be in the phone per se necessarily, but accessible to the phone? Is this the type of thing we're dealing with?
Well, it's not that straightforward. It really would depend on the setup of the actual individual themselves and where they want to keep their information. So if it were accessible to, I would say something similar to like a OneDrive, and they were to store their communications off of their device on that OneDrive and accessible from any device which they might want to access it from at a later date. That would be a good example. But it's also possible that they download those communications and keep them on their device, I guess, on a local drive within the device itself.
Right. My point is that within our devices, we probably don't even realize what's there, most of us. But within our devices, for instance, I was just looking up an investment, and I won't get into the details of things, but if it looks at my face and says, yeah, your password is good, it can then access what's on that website, right? Is the current practice now to say, look, by having your device, we have access to what your device allows us to get to? In other words, that investment portfolio is password protected. We get your password, which now gets us in there, but we have a judicial authorization, as in a judge has said there are reasonable grounds to believe an offense has been committed and that there's evidence to be found in that place. Is that where it gets us? I hope I'm being clear here.
Correct. That would be accessible to, would be essentially in control of. So that would be in possession of the device itself.
Because otherwise, a nefarious actor could simply store everything off of their phone. I mean, not unless you were a digital guru, which there are out there. There are people who are very careful. I mean, people who are nefarious are often very careful. So this is to prevent somebody from storing everything that is inculpatory, if you will. If somebody were to store everything inculpatory and you were to seize their phone, if this amendment were to go through, you wouldn't be able to necessarily get the contents of that inculpatory information because it's held elsewhere, like outside, air quote, of the device. Is that correct?
That would be you see that, for example, with a shared device. So there's one family computer, and an individual will not store the incriminating evidence on that device, but they will store it in the cloud and simply access it from the device.
See, and that's also an interesting point because there's a body of case law, as I recall, at least in British Columbia, that talks about waiver of charter rights. My understanding, and it's been a number of years, that one person cannot waive the charter rights over another person's. If a person has an expectation of privacy in a device and there is joint control of the device, person A can't waive person B's expectation of privacy. Are you with me here so far?
Yes.
So if this amendment was to not go through, you could have a situation in which somebody has, could you have a situation in which there's a joint cloud, if you will, but you're dealing with, well, who has ownership of this? Would that come into effect as in an expectation of privacy there?
Well, in this case, we're using a warrant to obtain that information, and I think what you're alluding to is more a consensual search that's been provided by someone else who has control or who has access to the device.
Thank you. I think I have enough information to make a decision here.
Merci, Monsieur le député Caputo. Le député...
Thank you, Mr. Caputo. Mr. Housefather.
Because I don't think this is so difficult. Can you just clarify it? Because I think this is the simplest. There's a child pornography ring out there, and all of the members have access to a OneDrive where they store all of the child pornography materials. If this wording was changed per this amendment to NDP 1, you would not then be able to do anything, even though you have a thumbprint of the picture on the device, correct?
Correct.
Okay, I think that is logical enough that hopefully everybody can vote now. Thank you.
Okay, thank you, MP Housefather. Est-ce qu'il y a d'autres interventions?
Are there any other interventions? Sorry. Is NDP 1 adopted? No. NDP 1 is defeated. That brings us to BQ 1. Ms. de Bellefeuille, would you like to propose it? Thank you, Mr. Chairman, of course. Our amendment was from the Barreau du Québec brief. The objective of it is to add safeguards to better safeguard extraction of data. This was a recommendation in the Barreau du Québec's brief that was drawn to our attention, so I submit this amendment to members of the committee. Thank you, Madame de Bellefeuille. Yes, respectfully, I would say that the ultimate goal of this bill is to accelerate procedures so that investigations can take place within the desirable time frame in real time. So with this kind of regulation, there will clearly be much longer delays that will prevent investigations from concluding. There is definitely a question of efficiency here. This is why we will be voting against this amendment. Thank you, Mr. Ramsey. Mr. Caputo.
From the officials, one of the things is limited to the class of computer data specified. What are different, could somebody please give us different types of classes of data? Like how it would, and would that mean that every type of class would have to be enumerated within a warrant? Does that make sense?
Thank you for the question, Chair, if I may. The description of class, which is no longer in C22, this articulation was actually in C2 when it was first introduced, and what we intended then, and I'm not sure what the Barreau de Québec intends here, but was that the judge could impose the condition that the search can only go after photos or certain file types, email clients, things like that. So that it was, again, these are only examples of the conditions that a judge may be able to impose. But that's what was intended back in C2.
So I'm clear, that's not what's here, but would this amendment would restore that, as in it would have to specify every type of data class that could be of information that could be obtained?
It would, and as you know, there was a series of consultations and roundtables held between C2 and C22, and a lot of the stakeholders from the law enforcement side said that it's unnecessary, and there's a variety of law enforcement stakeholders in Canada, like hundreds of police detachments, all in varying sizes and resourced differently. And it was felt that placing these conditions could become the norm, so which would be inappropriate for some police detachments. So we still didn't want to remove the scope of the discretion of the judge to impose conditions that are reasonable in the circumstances. So that's why the new articulation
is there in C-22.
In these current circumstances, then, a judge still has discretion to put parameters on the type of data. It's not the de facto way. Is that, do I have that right? I'm just trying to get that through my head. I'm sorry.
The judge has full discretion to impose any conditions that he deems appropriate in the circumstances.
So this would this amendment then narrow the judge's ability to impose those conditions or fetter judicial discretion in any way?
I think part of the issue with the amendment is that it really does not have any legal effect. What it does is, because the way that it's articulated in the motion is that it's including these conditions, so it's non-exhaustive. So these are just examples of conditions that a judge might be able to impose. So I don't think it narrows it. It does nothing exactly to the scope of the conditions that might be able to apply, but there is a risk that these conditions become commonplace because they're articulated and in the law itself.
Oh, I see, because if a provision says you need to look at X, Y, Z, then the industry practice becomes to include X, Y, Z, even though, because as you said, it's non-exhaustive. And if it's non-exhaustive, that means you can, as you said, include anything. So from what I'm seeing, there's a limited practical benefit that may come from your point of view, Mr. Wong, but it could add a layer of complexity down the road. I don't want to put words in your mouth. That's just what I'm taking from you.
I think that's what we've heard from the stakeholders, is that they're afraid that these conditions may be imposed in circumstances when it's not appropriate, just because they're articulated in the provision itself.
Okay, thank you. Those are my questions on that provision.
Ms. de Bellefeuille, I was curious because, of course, to me, the Quebec Bar Association is a good reference. They're lawyers who have a good reputation, especially those who draft briefs. What I find unfortunate, Mr. Chair, is that we heard the Canadian Bar Association, but we didn't get their brief or their proposals for amendments, because there are apparently translation problems. So I'm wondering if the Canadian Bar is someone that you consult. I know maybe not the Quebec Bar, but I'm surprised that you're saying, you know, this amendment doesn't change much. If the parliamentary secretary tells me that this would be serious, you've said, what I've understood is that it wouldn't change that much, this amendment. That's what I understood anyway. Yes, and thank you for the question. 2 weeks ago, when we talked to the Canadian Bar Association about, on the agenda we had C-22, they didn't talk about on part one. Yes. Okay, thank you.
Merci, Madame.
Thank you, Ms. de Bellefeuille. Is BQ1 adopted? No. BQ1 is therefore defeated. Is Clause 3 adopted? Clause 3 is adopted. Let's go on to Clause 4. Is BQ2 proposed? Ms. de Bellefeuille. Yes, indeed. This amendment reflects the will told to us by the commissioner, the privacy commissioner, to limit the kind of information that can be confirmed without a warrant. This is to restrict this to telecommunications service providers. So we decided to be the voice of the privacy commissioner here. We have great respect for the commissioner, and she recommended that we restrict that information. Thank you, Ms. de Bellefeuille. Member Lloyd.
I thank my colleague for bringing forward this motion. Conservatives also respect the work of the Privacy Commissioner. He's been here at this committee on a number of legislative studies, and we always appreciate getting his recommendations. I wanted to ask, though, the appropriate witnesses who are here today What would be the impact of this amendment to restrict seeking subscriber information from any person who provides a service to telecommunications providers?
Thank you for the question. I'm trying to pull up the, do we have the actual motion? The notes that I have in front of me, and I'm just trying to match it with Clause 4, which I think is the definitions provision in 487.011. And the definition here will apply to all of Part 15. So it has sort of that knock-on effect of narrowing the scope of the production orders that mention telecommunication service providers. The confirmation of service demand will be focused just on them, but any other place where telecommunication service providers is mentioned will also be narrowed. I think in terms of providing police with a useful tool, this will again narrow the utility of that tool.
Madame de Bellefeuille?
Yes, go ahead. Well, Mr. Chair, I'd like to ask another question, with your permission. I think that what the goal of the amendment is, and the Privacy Commissioner was telling us, this is for the order that it requires an okay from the judge. Given your response to Mr. Lloyd, I'm having a bit trouble understanding your answer.
Merci pour la question.
Thank you for the question. I will check. I'd like to ask my colleague to bring me all the motions, please.
Je m'excuse parce que j'ai juste un parti de la.
I'm sorry, I only have part of the motion in front of me here.
C'est bloc. Okay. As I mentioned to Mr. Lloyd, the narrowing of this, the addition of this inclusion also would narrow the scope of the subscriber information production order. It has that knock-on effect, and currently the subscriber information production order is servable. You could, on any person who provides a service to the public. So it's designed that way to ensure that police can obtain customer or subscriber information from any entity that might have relevant information for the investigation of a crime. So the inclusion of this would also narrow the subscriber information production order, because this, I think, comes up in the context of what I understand the amendment and how it works with the bill, is that it goes into the definition section. So it has that knock-on effect.
But Mr. Chairman, in the speech by the Privacy Commissioner, one of his arguments was excluding certain sectors such as telemedicine or any information about health or professional confidentiality. He was referring to that in his brief. In the bill, there are clauses about that, but in the definitions, if that is not restricted, we're wondering whether there couldn't be some kind of abuse to get confidential information from regarding doctors or other professionals. Thank you for the question.
Came out and there was concern around the scope of the information demand, which is now the confirmation of service demand. those concerns articulated by the critics were mainly related to the fact that that was a demand that police could issue on their own without any judicial oversight. This would form part of a criminal code production order, which is issued by a judge. So the judge has discretion as to what is appropriate or not in the circumstances. Police, for a variety of reasons, may require information from all sorts of service providers, including hotels, car rental agencies, medical clinics, and things like that. But in order to get that information, they have to go before a judge and justify why they need it. So I understand what the Privacy Commissioner is trying to do, because if you limit the class of people that can be served with this, you will restrict the amount of information. The corollary to that is that there ends up being a differential privacy, the differential privacy treatment of information in other service providers' hands. They either get more privacy, or because you'd have to use a tool like the general production order, the people who have their data with those other service providers that are not covered, because this would narrow it. So if it wasn't with the TSP, it would be under a general production order. The general production order allows police to access any and all information the service provider has on hand. So it would almost have a negative effect, because the privacy would be more at risk, because police might just want to identify victims or people who are actually not persons of interest, but because they'd have to use that tool, they'd also be able to obtain all the information on them. So the amendment is problematic from a number of perspectives.
Mr. Chairman, in closing, I'd like to point out to Mr. Wong that you speak very slowly, and the interpreter interpreting you, it can follow you. I want you to say that you're a model witness. And it's true, because it's so technical. When everything's going on in English, you have a good rhythm, a good pacing, and I appreciate that. I'm sure we'll hear you often. Maybe inspire your colleagues, please, because you have the perfect pace that allows interpreters to help me follow the discussion and understand you. I can tell you that what I feel, of course, you're not here to say that our amendments that protect privacy are a good thing, because your mandate is to defend C-22. We understand that throughout the bill, I'm not expecting you to say, yes, this protects privacy and we should do that. I think your bias is to give more access to law enforcement, but our job is to strike a balance and say, yes, it will restrict that, but if we restrict it, would it be that serious? Because the risk of not protecting privacy also carries a price. And when you answer me, we can see that you are defending the needs of law enforcement, perhaps a little less the need to protect privacy. So I just want to say that if we're told, yes, it wouldn't be such a bad thing, but it would prevent the police from doing their job, well, that's quite a general answer. That's what I'm feeling, Mr. Wong. I don't want to put words in your mouth, but I'm explaining what I feel. What I understand is that the amendment was proposed by the Privacy Commissioner. His job is to protect privacy and information. So, of course, he will go toward protecting it. You're saying I'm not convinced that this amendment would be dramatic for police services. What I feel is that you're biased toward the police and not the protection of privacy. I just wanted to point that out, and I thank you.
Merci, Madame de Bellefeuille.
Thank you, Ms. de Bellefeuille. MP Caputo.
Thank you. I note that Ms. de Bellefeuille said Mr. Wong was a model witness. She didn't call me a model parliamentarian, so I'm a bit hurt by that. But anyways, on to more important things.
Next.
This is the way we characterize the definitions in this section are actually pretty important. Like this is, I think, actually, we're early on in the amendments, but this is a very important amendment, in my view, and a very important issue. So when we're talking about, right now we're talking about subscriber information that can be sought from a person who provides a service to the public. And you may have, I think you touched on this, but what categories could be included in that? A person who provides a service to the public. What could that include, please?
Thank you for the question, Mr. Chair. Just answering Madame Belfoy's question also, just to add on, and I think what my colleague was expressing is that the subscriber tool is judicially authorized by a court who balances both the privacy interests and law enforcement interests. So it's law enforcement versus privacy interest neutral, and would apply to everyone. I think that is a really important point. Is just to remember that this is a judicially authorized warrant for basic information, name, address. Basic information. As it relates to medical information, that provision doesn't speak to providing any content of anybody's service information, no medical information, again, name, address. And so just in terms of the tool itself, it is a tool for law enforcement to investigate crime, again, judicially authorized, so it has to balance those privacy interests. And so I think it's pretty straightforward. It would be everybody who provides a service. So if a law firm is providing a service, a car rental, my colleague identified car rental, any sort of service provider, the law enforcement can go to get a judicial authorization to ask the court for a court order to provide somebody's name and address.
I take your point about judicial authorization. I think the point that's being attempted to be made, but perhaps I shouldn't be so bold. The point I will attempt to make is this. As I understand this, we are looking at a streamlined process in order to get information. That this is a way that law enforcement has said we spend way too long getting really basic information. So this is why we use terms like confirmation of service demand rather than going out and getting things. So if right now we're looking at the confirmation of service, my understanding was the whole point of that was to streamline the process. But in so streamlining the process, it was to say the privacy interest that is being impugned or questioned is low because it's like, are you a customer? Are you this? Are you that? That's for the narrow category of service providers, so to speak. And I think we all were thinking the classic being the IP address, or are they a service provider of Bell, or are they a customer of Bell? When you start talking about streamlining getting information from a hotel, for instance, and things like that, I think that's a lot different. And I'm mindful of the fact that is this person a client of the hotel, as in did they stay there or not? But to me, that's a lot different of a privacy interest that is being streamlined than is this just a customer? I hope I'm making sense here. How do you respond to that?
Thank you for the question, Mr. Chair. So again, the confirmation of service demand is scoped narrowly to telecommunication service providers, and so you're 100% right. Bell, TELUS, is Kim Gibner a client of yours? Yes or no? Streamlined process. That is one tool. The subscriber production warrant is also basic information, so name and address. But because it's not just is Kim Gibner a client of yours, it's actually what's Kim's address. That requires a warrant. That is not just narrowed to telecommunication service providers, as this amendment is requesting us to do. It is currently drafted to apply to all people who provide services. So two different tools and two different standards.
Sorry, what's the different standard? I must be missing that.
So the confirmation of service does not require a warrant. The subscriber production order requires a judicial authorization.
I see what
so
you're
one is
saying.
very, very tailored. It's just to the telecommunication service providers, yes or no. Don't need a warrant. You do not need a judicial authorized warrant. And for the broader information, what's Kim Gibner's address? You need a judicially authorized warrant, and that applies to all people who provide services.
But that judicial authorization is done in a streamlined manner. That's the whole point of this.
If by streamlined manner you mean the test is reasonable grounds to suspect, yes.
There's no prescription in terms of how would I put it?
Streamlined process other than the standard. Reasonable grounds to suspect is calibrated to the nature of the information.
Whereas it's commensurate with the diminished privacy interest.
Exactly.
We say that there's a reasonable ground to suspect and not a reasonable ground to believe because we only want your name and address. We don't need to go to. The law enforcement should be able to get that based on suspicion because all we're getting is your name and address. If we were getting your personal details, we would be getting your reasonable grounds to believe.
That's
so
exactly
then
right.
within that context, I guess I've spun myself into knots. Then how does this amendment change things?
This amendment says for the it wants to circumscribe this judicially authorized warrant tool only apply to telcos like the confirmation of service demand does.
But if that's the case, could you not just get a production? Like if all we're dealing with is telcos, could you not just go and get a production order and say, give me Frank Caputo's name and address from the hotel he stayed at? Could you not just do that? What's the difference there?
Again, just so we're using the same language, that's what this subscriber information is. It's a production order, and we are getting a judicially, the amendment is proposing that we go and get a judicially authorized warrant to get Mr. Caputo's hotel information, whatever your example was. I apologize. And so if this amendment was passed, then of course law enforcement would be back to the reasonable probable grounds of a general warrant that we use to search your home in order to find out whether you rented at Hertz or at Budget.
So the status quo is a more arduous process. This is trying to maybe streamline it isn't the right word, but simplify it. And the concern, I suppose, from the officials is if we were to accept this amendment, we would be simplifying it in some respects, but not in other respects, and the status quo would still exist, which is a general warrant to go and search my house or I can't remember the analogy you used.
You have set that out correct, and my colleague's just suggesting that it might be helpful for the committee's deliberations if you want concrete examples for the RCMP. But
examples are always helpful.
Thank you for the question, Mr. Chair. In this case, if we're thinking about our grounds, at the beginning of an investigation, and I'll use an analogy, basically a very simple investigation that hopefully everybody would be able to follow for the difference. If we were to take, for example, a stolen bicycle. So someone calls in, says that their bicycle was stolen, and they say that their neighbor, Phil, stole it because he told me he would. So now there's no reason not to believe this person who we're going to call Mike is declaring his bike has been stolen. So we're more or less at reasonable grounds to suspect. We can suspect that there's a bike that's been missing. We can suspect that, potentially there was somebody named Phil who might have been responsible for that. But we haven't reached the threshold of reasonable grounds to believe because we haven't confirmed or corroborated any of the information that's been provided. Now, if it was the same scenario and he came to the detachment and made the same declaration. But this time he showed text messages from his neighbor Phil that said, Phil said that he would steal my bicycle on Tuesday, and I'm also producing a door cam footage of someone who meets the description of Phil stealing a bicycle from his lawn and walking towards his house from the Tuesday. And when you do your police checks, you see that someone who does live beside this, the victim, is named Phil and has been known to steal, has been arrested 7 times for stealing bicycles, and his mugshot matches the description or what you see in the doorbell cam.
Okay, sure. So yeah. This is interesting to me. So does this just come down to, like, because we're going to be getting into the reasonable grounds to suspect, but reasonable grounds to believe. If I've understood what you're saying, this all comes down to basically taking this down to the lower threshold of reasonable grounds to suspect for a certain class or a certain amount of information. Because, like, and sorry, I know Mr. Housefather was talking about, like, let's just get to it. The whole reasonable grounds to suspect and reasonable grounds to believe is going to occupy a fair amount of time of my questioning. I'll tell you that right now, because I know what reasonable grounds to believe is. Reasonable grounds to believe, in my view, is that you personally believe something. That's the subjective nature of the belief as a police officer, and that belief is objectively reasonable. As in, a reasonable person would also say you have a basis on which to believe. Do you agree? It's been a while for me. Okay, so can somebody help me? What does reasonable grounds to suspect mean legally? Because I just laid out the legal test for reasonable grounds to believe. I don't know what it is for reasonable grounds to suspect. Can someone help us there?
If I may, there is case law that talks about the reasonable suspicion standard, and it's been described as a reasonable possibility instead of a probability. So reasonable grounds to believe is more of a probability, while reasonable grounds to suspect is a reasonable possibility.
Interesting, because I always thought reasonable grounds to believe was not to the level of a prima facie case. And a prima facie case is there's something there that you can get. So maybe I'm just confused because this is a very technical area of law. Because, yeah, when I think of something, you have reasonable grounds to believe that an offense has been committed, and is that reasonable? So we're talking, Mr. Wong, if I take your point, this is just, has something happened? Yeah, it may have happened, but that's, I suppose, a bit inconsistent with my understanding, but I might be out to lunch on this. So thank you very much.
Thank you, MP Caputo. Monsieur le député Housefather.
Monsieur le Président, et je vais essayer d'aller.
Thank you, Mr. Chairman. I'll try to go very slowly because I understand that the interpreters have some difficulty when I speak too fast.
I wanted to encourage everyone to use actual examples of how things work, because I think it helps us when you have concrete examples of how words will change the bill. I appreciate that we got to that point, but maybe that's a good starting point. For example, here, what I understand is that a telecommunications provider, if we change the wording to telecommunications provider, we then no longer have the ability to use the lower grounds of reasonable belief to obtain a warrant and search. And so, for example, let's say we have a human trafficking case where you have a report that there's this middle-aged man with a young woman or a number of young women that has been staying at this hotel, that went to this car rental agency, that has this bank account, and you need to obtain quick information from the bank, from the rental car agency, from the hotel, to try to find the victim who may be with this gentleman. You only have a report. You haven't done independent validation to get you to a belief standard, but you have you've reached the suspicion standard. Because of the way the law is now worded, you would be able to go to those different service providers that are not a telecommunications provider to obtain important information such as bank, are you a client of this bank? Were you at this hotel? Did you rent this car? Right? I mean, that's essentially the point of this, and that's what would change with this block amendment. So I understand that we will eventually get to a profound debate about whether or not that standard should change or not, that Mr. Caputo, I'm sure, will what would be the right words that he used for himself, nerd out on. But for the moment, while we do have that different standard in the bill, the purpose of this amendment, should we eventually remain with the reasonable belief standard, this amendment would thwart the intention of the bill to allow that lower standard for a number of service providers where you may need to obtain important police information. Is that correct?
That is 100% correct.
Okay. I know how to vote. Thank you.
Merci, monsieur.
I just want to make a point on this because I never, ever usually pause something live just to make a point. But if that was the case, then why did we allow that two ISIS members to come into Toronto where we weren't even aware of it until the French tipped us off and until the CIA tipped us off that they were planning an attack in Toronto? Like, I'm not sure what more you wanted by achieving this. If you have this bill today, or if you had that bill 2 years ago and is already in law, do you think you were going to catch those ISIS members any more quickly? Like, I'm not sure what your reasonable grounds is on that to be able to like he's making an example of, oh, if somebody went and rented a car and used a bank, like I'm going to be able to find out their information much quicker. Like, CSIS already has that in the Anti-Terrorism Act. Like, it's already right there. So if somebody wanted to, if CSIS from an executive level wanted to make a decision quickly, they can do that. This is more just sweeping towards average citizens. Anyway, I could keep going on about this, but I just find that his whole entire point there was ridiculous.
Thank you, Mr. Housefather. Mr. Mantle, please.
Thank you, Mr. Chair, and thank you to our officials for being here. Mr. Wong, you made a comment that I want to start with during the last amendment, but it'll be relevant to this amendment. That you, in discussing the previous amendment, you noted that it includes the word, or includes the word including, and so therefore, in your opinion, had no legal effect. Did I summarize you accurately? Oh, yes. Okay. You're familiar, of course, with a basic legal maximum that all legislation speaks. So is it not the case that when Parliament includes something in legislation, that a court is required to consider why, in statutory interpretation 101, consider that in its. So do you want to revise your opinion that saying including the word including in legislation has no legal effect?
I don't think I said it had no legal effect. I think the change was between what the current wording was in the conditions, which gave the judge broad discretion to impose any reasonable conditions upon the search and examination of a computer, amounted to the exact same thing as the articulated examples of conditions, because the judge still has the discretion to impose those conditions if they so choose.
Okay. No, it just helps me understand where you're coming at this, because I would certainly take a different view of that. I mean, a judge considering a piece of legislation that's got specific criteria, even if it is a non-exhaustive list, if they simply ignored that, I think that would be problematic and probably grounds to appeal that decision. So that's helpful just to know where you're coming from. Because I'll come back to that non-exhaustive list issue in a second. With respect to this amendment BQ2, Ms. Gibner, you made a comment with respect to BQ2 that it's in discussing subscriber information, it's only basic information. Am I quoting you accurately?
Yes.
Could you tell me where in the clause of Bill C-22 that describes subscriber information that it's limited to only basic information?
So the subscriber definition sets out exactly what it is, and it was my characterization of what that list is.
And so if you go to that clause, and I might ask you to bring it up so you have it in front of you. You let me know when you've got it ready.
The definition
Subscriber information, yeah.
I have it in front of me, yeah.
Okay, in A, B, and C, as I read it, each of those subsections uses the word including, does it not? So A says including their name, pseudonym, address, etc. Subsection B says including account numbers, and then subsection C says including 1, 2, 3 listed. Is that right?
The word including is in all of those paragraphs, yes?
Yeah, right. So as we just established, using the word including creates a non-exhaustive list. So is it not fair to say that in this definition, it's nowhere limited to, as you describe, only basic information?
So my read, if it assists you in any way, is that the first part of the sentence clarifies the including, right? So it's just the including is giving examples of what the first part means. So for example, in A, it says information that may be used to identify the subscriber or the client. So that's the point of the sentence in my opinion. And so then they just give examples of how you might identify someone. So for example, their name, their pseudonym, their address. So I see those as describers, and I would characterize all of that information. That's just my characterization as basic information.
Well, that's a significant difference of opinion in my opinion, because when you use
Sorry, I missed the first part of your sentence. I'm sorry.
I was just saying, I think we have a significant difference of opinion on what the drafting means then, because the use of the word including has been litigated and is clearly understood to mean a non-exhaustive list, not just a list of examples. So I don't think that anything in A, B, or C is limited at all.
Sorry, so I agree with your general proposition about what the word including can mean, and including as how you described it with my colleague. But you don't have to do anything. but
advice though.
But how I read the section is reading the chapeau too, right? Like it's pretty clear. It says this is like it means this, and then that's just my interpretation.
Okay. Fair. I guess we can take a different interpretation, but this is why we're going through this, because as I said, each word in a statute is important, and it's not there. There's nothing superfluous in law, right? Another maxim. We'll see how many we can get in today. I wanted to pick up on something you said, Mr. Wong, about this amendment. You were describing, I think you said that regardless of what happens to this amendment, whether it's narrowed or not, there's still a general production order that can be sought. Is that right?
Yes, that's correct. The general production order is available.
Right. I think you made the comment that these BQ amendments would weaken privacy. Am I capturing your thought accurately?
Yes. I think the current scenario that we now live under, because there is no specific production order for subscriber information, means that any time police need subscriber information, the only tool they can get is a general production order, which gives police access to any and all information. So,
and when you go and get a production order, it's subject to the conditions that are attached to that production order by the court, correct?
That's correct.
So is it fair to say that actually in each case, those production orders can be limited as the court might determine in a case-by-case basis?
They can be, but you're asking the police to jump through the hoops of getting a reasonable grounds to believe production order, which has a higher evidentiary threshold.
I'm not arguing about the threshold. I'm just arguing about your characterization that these amendments weaken privacy, and that the general production order, they weaken privacy because police would then have to go and get a general production order, and those can be for anything. My point to you and my proposition is that's not accurate, because each production order, in fact, will be tailored to the request of the police. And so in each circumstance, it wouldn't be just, it may not just be a blank check. In some circumstances it may be, but in many it won't be. And I can't speak from experience on that. Maybe the police can offer their their view. But I think as a proposition, that's not accurate. How do you respond?
Respectfully disagree. These tools have been designed, the general production order. You can think of it as a fishing net, and the fishing net grabs anything and all that's in the sea. The specific production orders are like jiggers or fishing rods. They're designed to catch specific fish. So if the only tool that you have is a fishing net, you catch whatever. And to ask police to actually jump through the evidentiary burdens of meeting these things, just in case they need the information later, they'll ask for everything in case that person ends up becoming a prime suspect in the investigation.
Mm-hmm. Okay, thank you. I think, in fact, you're actually making the point that the Privacy Commissioner made, which is the broadness of the definition, the broadness of who these apply to is the problem. And to me, you're just confirming that problem. And these amendments are, I guess, trying to narrow that and maybe make it, to use your analogy, a smaller net.
Thank you very much. Avant de procéder,
Before we proceed on our decision on BQ2, I'd like to inform you that since BQ2 was proposed, CPC1 cannot be proposed because both are identical. And if BQ2 is adopted, BQ3 and CPC2 cannot be proposed because of a conflict in lines. Conflict in lines arises when a committee modified the line of one clause once and cannot modify it again through another amendment. In other words, a line can only be modified once or amended once. So, since this has been shared, is BQ2 adopted? Recorded division, Mr. Clerk.
La question est...
Thank you, Mr. Chairman. The question is on Amendment BQ2. Mr. Ramsey.
Mr. Housefather.
No.
Mr. Maloney.
No.
Ms. Akan.
No.
Madame Dandurand.
No.
Ms. Sodi.
No.
Mr. Caputo.
En favor.
I beg your pardon, I'm sorry?
In favor.
Oh, I beg your pardon, thank you. Mr. Lloyd.
In favor.
Ms. Kirkland.
Yes.
Mr. Au.
Yes.
Madame de Bellefeuille.
Pour?
Yeas pour 5, nays contre 6.
merci, Monsieur le Greffier.
Thank you, Mr. Clerk. The amendment is defeated. CPC1 is identical, so now we go on to BQ3. BQ3 is proposed? Yes, Mr. Chair. So the amendment, once again, this is a recommendation from the Privacy Commissioner. His desire, if I understood correctly, is to slightly restrain information about the subscriber. We are to understand, Mr. Wong, I don't understand all the English expressions, but, you know, to our mind, this bill is important. It shouldn't be a big fishing expedition. There has to be some restrictions so that it's not just total carte blanche for the police to infringe on privacy. So the amendment I'm proposing is not as restrictive because in French we see the word notably, notamment, so there is some discretion by the judge, but it's important to point out nonetheless as an instruction that our desire is to not rake very broadly and to restrict information about the subscriber. So I hope that my colleagues will support my amendment. Thank you, Madame de Bellefeuille. I inform you right away that there's a line conflict between BQ3. I'm sorry. Because BQ3 is proposed, CPC2 cannot be proposed. It hasn't been considered yet, but it's identical to BQ3. Any interventions? I already have Ms. Kirkland and then Mr. Caputo. Ms. Kirkland, please.
Thank you. I appreciate this, and Madame de Bellefeuille, you said something very important as we're listening to department officials, and I appreciate that you're answering a lot of very technical questions and you're doing the best that you can. But she was right when she said that your job is to give more access to law enforcement. I mean, this is the purpose of this bill, is to give more access to law enforcement, but our job is to balance, truthfully, Canada's charter rights to privacy. And we really, really have to do that. And I would hope that when we ask these questions today, that I'm hoping that you consider those things as well as we ask those questions, and not just the one side of things. I guess that's all I'll say on that. So anyone can answer, whoever. Is it fair to say this amendment improves? I mean, I think it improves legal precision, right? It ensures that only clearly identifiable information is captured rather than broad or potentially ambiguous data types. Would you say that's fair, or do you have anything to add?
Thank you for the question. Keeping with my previous intervention, I think in a non-exhaustive list, this has limited legal effect. Removing it doesn't mean that someone might consider the pseudonym as part of the subscriber information they might be able to provide. I don't think it does much one way or another legally.
So sorry, clarify that very last thing you said. It doesn't do anything much one way or the other?
Yes, because this is a non-exhaustive list of potential identifiers that can be ordered, right? So the way that it's drafted now, removing pseudonym from there would be less instructive, but that doesn't mean that a judge could actually order pseudonyms to be produced if the service provider had them on hand.
I'm sorry, I'm just trying to wrap my head around. So does removing pseudonyms from the definition then strengthen the principle of data minimization by ensuring that only necessary and clear attributable information is included? Because that's how I'm seeing this.
I think the reason why it was included is because there is a need sometimes, depending on what someone, how they've set up their account. So if you set up your Instagram account and you characterize yourself as Daffy Duck, and Instagram has information on Daffy Duck, they'd be able to provide that. This is why it was added. Whether or not that leads to data precision in terms of privacy safeguards, I think that's debatable. What the tool is trying to provide is information so that police can identify suspects.
In a nutshell, you're saying that this amendment doesn't reflect a balance between I'm trying to get to the point that we're looking at balance, right? Balance between effective investigative capability, but also stronger privacy protections for individuals using telecommunications services. So with that balance in mind, you're not, if it doesn't matter one way or the other, then we might as well preserve as much privacy as we can. No? Am I completely misunderstanding where you're going with this?
Perhaps, or I'm misunderstanding you. I think, again, the elements in the subscriber information definition were there to give examples of the types of information that police need during an investigation in order to identify criminals. So the reason they're included is because there are real-life examples when they might have to go after a pseudonym, or they have a suspect and they know this person via an IP address, and that's why they've gone to Rogers, for example, and ask them for the subscriber information. And if Rogers has on hand any pseudonyms that that client used on their services that is registered with them, for example, email addresses they might have registered with them, they could provide those.
Could I ask perhaps Mr. I'm sorry, I can't see your name. Gilks, is it? Mr. Gilks? Sorry, the angle is bad for me to see your name. I apologize. You know, so let's talk about concrete, real world examples. Can you give us a couple of those? Maybe a couple that are different, so that we can really wrap our head around it.
Sure, absolutely. Sorry, excuse me. We do have to keep in mind that we're police who are investigating most of the time criminals. We do investigate missing people, things like that. But if we are investigating criminals, then likely they're not going to want to use their real identities when they're registering for various services, especially if they're going to be committing crimes online. As this is the case, some of the time we have to use some other ways to identify the potential individuals or the potential people who could be behind whatever crime it is that we're investigating. So we may be asking for information that very much differs from service provider to service provider. We don't know exactly what is required to create each account, whether there are monikers that can be created and associated with a name that has been associated with the creation of the account. And these are, somebody may have multiple accounts associated with a particular name. And whether they're called handles, whether they're temporary, permanent, things like that. So this is information which can be provided to police, which can help them link these individuals to other platforms, to previous registrations in other places, which can then have those police officers continue with additional judicial authorizations to obtain additional information.
Is that all right?
I think so.
Yes. MP Caputo?
I don't feel at all confident in all of the answers, but I'm getting there. I'm getting there. Do you have any other examples that you want to give? Or maybe Frank can help me clarify my thoughts.
I think what this comes down to, if I've got it right, maybe I don't, but what I've got, if privacy commissioner says you shouldn't include pseudonyms, that's the recommendation. The police are saying, well, including pseudonyms will help us catch criminals. And perhaps what I can do is to say this. If someone could finish the following sentence, including pseudonyms will help us catch criminals because. Please go ahead.
Because criminals use pseudonyms.
Okay. Okay. So criminals use pseudonyms, but I think we need to go one step further. And I have a great deal of respect for you, Ms. Gibner, and I know you really know your stuff. So I understand criminals use pseudonyms. I don't have a burner account. Very proud of that. So a lot of politicians do. I do not have any burner accounts with which I attack political opponents. But obviously, why are you laughing, Mr. Housefather? Do you?
I definitely do not.
No, okay. I think we need to.
I didn't even know it was possible.
You didn't know you could have a burner account, Mr. Ramsey? Oh, good grief. I don't know if I buy that. But anyways, people use burner accounts, obviously, or pseudonyms. I'm talking about burner accounts. Pseudonyms are used in order to not identify yourself, if we're being candid. Is your point that we want pseudonyms simply because that might be akin to a username, like, you know, Frank Caputo MP is my username, but somebody else might use, I don't know, like somebody said, Daffy Duck as their main thing. Why is that necessary? Why can't we still get the person's information without the pseudonym, I guess would be the logical point. I think I know the answer, but I think we need to flesh that out based on what Ms. Kirkland was getting at. I think that was the point she was trying to get to. Is that accurate?
I think, I mean, I'm going to go back to the point I made earlier, right? This is a judicially authorized warrant. And so police are going to go with the evidence. They're either going to go with a Daffy Duck or they're going to go with an IP address and say, I need it associated, right? This is the purpose of the tool, is to connect a first initial dot at the beginnings of an investigation. And so the police don't know what they don't know. So the warrant is set out, or the definition is set out for the various things that they've come across in real life, and they're trying to articulate. We've articulated that in law to be as clear as possible. But first principles are that they're going to have to go to a judge with some evidence in order to get it authorized.
And the evidence would be predicated on connecting the dots, and if I take your point correctly, the dots don't get connected if we don't have the information, and the information we need is sometimes in the form of a pseudonym. Is that the point?
My point, and again, I think, I think it's really helpful to the committee to hear examples. So maybe if Mr. Gilkes is an example of a pseudonym that sort of, connects the dots for us all here, maybe that would be helpful to the committee.
Yeah, Muscle Man Frank or something like that is a very good place to start, Sergeant. I'm being facetious here, but well, let's ask this: what percentage of people in your investigation use child luring, things like that? Because in my experience, a lot of people do use pseudonyms, but a lot of people don't. A lot of the time, when you get a report, for instance, that says this is the person, they will have often logged in with their real name, or their Facebook is tied to their actual email address that might be like francaputo@rogers.ca or something like that. Do you get what I'm saying, Sergeant? No, that is not my real email address. You're going to get bounced if you try to email that.
Millions of Canadians are sending you emails right now, Frank.
Right now, including Mr. Housefather's burner account. Sergeant, is it Gilkes or Gilkes? Sorry, Gilkes. Sergeant Gilkes. Can you elaborate on what I've said? Like how often does this happen, that the pseudonym is just so important to an investigation that it's absolutely necessary?
Well, I don't have exact numbers.
Fine, just in your experience.
Anecdotal. I mean, I've investigated many different types of crimes, whether it be financial or cybercrime investigations, and depending on the type of crime being committed, and depending on the how widespread the crime actually is, that's when it comes more into play that we see. So I'll give an example. In cybercrime investigations, there's something called pride. So cyber criminals a lot of the time start off as gamers, and they are particularly good at a particular game. And this is something that may come back later on. They may use a moniker that they used many, many years ago because they're proud of what they've accomplished in a certain game. And that game, or that name, may be used sometime later when committing an offense, and you're able to link that name that's being used sometime later to an account that was created years before in a particular game. And that gives you some insight as to who might actually be behind the offense.
No, and I understand. So that I can understand. But in your experience, is this a frequent thing? People might use a moniker or something like that, or a name from something in the past, a reference to gaming or high school or being a good skateboarder or something, right? The question I'm trying to get at is this: in your experience, is that very frequent, sometimes occurring, seldom occurring? That's what I'm trying to get at. And again, you can only speak to your experience, so I'm not trying to qualify you as an expert here. What I think the committee's asking for is, look, please explain, how often does this happen?
I think particularly in cybercrime, I'll refer to cybercrime. It does occur often because you're dealing with in an anonymous space. For example, you'd be dealing on the darknet, and the whole purpose of dealing on the darknet is to avoid detection, remain anonymous, and so that helps in terms of a lead when you're operating in this type of space to potentially target an area where you can accumulate additional information or additional evidence to help to prove your case.
Now, that doesn't mean that you couldn't go and get a production order at the higher standard of reasonable grounds to believe for the pseudonym, does it not? That you're not precluded from doing that, correct?
You're not precluded from doing that, but the issue is at what stage of the investigation can you go ahead and obtain that information?
Saying that because at one point in the investigation you may not be at reasonable grounds to believe, you may still be at the lower threshold. Is that accurate?
Correct, because one of the obligations that we would have if we were going to obtain a general production order would be we have to establish and show to the judge or justice, whoever is approving, that the person or the entity that you're requesting the information from is actually in possession of that information, which you need to confirm before you can actually go ahead and obtain your production order.
So this is all about grounds, and the difficulty with grounds, or much of this, really.
Well, for us, yes, it's expediting the beginning of the investigation because that's where an investigation is more crucial to get off the ground.
Yeah, it's interesting because, like, the reasonable grounds to suspect that Mr. Wong told us about earlier and the reasonable grounds to believe, like, I don't think those are, forgive me, help me if I'm wrong, but those are actually common law doctrines. Like, none of that is actually put in, is that in anywhere in legislation? Like, what, when I gave that definition of reasonable grounds to believe, like, that was my recollection from a case called Story, which was from the mid-90s about whether you have grounds to arrest. Is that enumerated anywhere in law? Sorry, I'm not going to look at you, Mr. Sergeant Gilks. Maybe that's something we as Parliament should actually be addressing, because if we're talking about grounds to suspect and grounds to believe, the common law can change, right? And maybe that's something, I'm just thinking out loud, that we as parliamentarians should be considering, is whether we need to codify what these grounds actually mean. So that may be neither here nor there. I'm sure Mr. Mansell has far more interesting things to say than I do, so I'll pass the floor to him.
And before we do that, I will list the names of those that I have already. So Mr. Mantle, Mr. Ramsey, Madame de Bellefeuille, Mr. Housefather, and Madame Kirkland. Given we're more than half time, I will suspend for 5 minutes so we can stretch a little bit. And then, so don't go too far, and we'll start in about 5 minutes again.
Wait, I was running to the bathroom. Why did he say he was suspending? I missed that last part there. Did he say he was suspending for 5 minutes and they're going to come back or something like that? Can somebody tell me? Anybody? Oh, okay. Bathroom break. Okay. Okay. In the 5 minutes, then we can check what the House is doing. It's still on for another little bit, but okay, it's a Liberal talking. Let's not listen to that. Okay, so this is Carney 20 minutes ago.
Tout d'abord, je voudrais accueillir Monsieur le Premier ministre du Grenade. C'est un grand plaisir pour moi, étant Premier ministre du Canada, de lui accueillir ici. Nos relations sont très étroites et il y a beaucoup à faire. I'd like to welcome you, Prime Minister, to Canada. I would like to thank you again for the honor of opening your embassy in Ottawa, High Commissioner. Welcome, good to see you again. I think it's a sign of our potential to deepen our ties, bilateral ties with Grenada, but also, and the Prime Minister has been one of the leaders here, despite his relative youth, one of the leaders in CARICOM, and deepening our ties within CARICOM. So we have much to discuss, both in challenges and opportunities, and I thank you again for gracing us with a visit for a few days here in Canada.
Thank you very much, Honourable Prime Minister. It's indeed an honour and pleasure to meet you, and please do welcome me and my delegation to to Canada. I certainly look forward to the meeting, and as you referenced, the opening of the ETHI Commission in Ottawa is not just symbolic. I think it recognizes the importance of the bilateral relationship between Canada and Grenada, and we need to strengthen and deepen it. So I think you will find it that Canada and Grenada has long, deep roots that are flourishing. And I think we have a golden opportunity to continue to ensure that we can make sure that our future generations of Grenadians and Canadians that the relationship continues to process. So thank you again very much.
Very good. Thank you.
You got a handshake, maybe, sir?
Oh, yeah, handshake. Yeah, without a doubt.
That's that. Quick little photo op. And then here's him with the barbarian prime minister as well.
Alors, c'est un grand plaisir de vous accueillir ici, Madame la Première Ministre Motley. It is a great pleasure on behalf of all Canadians. Officially, I know you've been in Canada for a day or two, and as usual, you've done a lot. But to officially welcome you here to Canada, we have a deep relationship between our two countries. But I want to say above and beyond that Prime Minister Motley is an absolute leader globally, a leader in obviously in CARICOM, a leader in this hemisphere, a leader globally, and not just a leader for today, but a leader for tomorrow. And you think about the areas where we're cooperating, and part of today will be about how we further that cooperation. Of course, on all aspects related to climate change, adaptability, resilience, both in terms of physical building, but the financing mechanisms for that, a number of things we're moving forward, but also in mitigation. And I salute again your commitment to 100% clean energy, and of course anything we can do, getting methane down, all these aspects. But the cooperation extends into pharmaceuticals. It extends into new technologies. It extends into professional services. Many areas, and only good things can come. And I'm very pleased to see you here.
Thank you very much, Mark. I want to say how indeed happy I am to be here. You and I know each other from a different space and a different place, and it gave me great pleasure to see you assume the office here. Even greater pleasure to see the leadership that you have been showing, not just for Canadians, but for the hemisphere and for the rest of the world. Barbados and Canada have had a long relationship, long before we were even thought of. But we've learned that where we have leaders who have a strong relationship, much happens. At the time of our independence, our then Prime Minister, Alvaro, was very close to your Prime Minister, Pierre Trudeau, and a lot has happened in the bilateral relationship, not only multilaterally. So today is about refocusing where we are with our bilateral relationship, how we can make it easier and better for Barbadians and Canadians to continue to work together. A lot of our business in Barbados is dependent on Canadians. A lot of our tourists in Barbados come from Canada. A lot of Barbadians have family and relationships in Canada and have added value. The chairman and CEO of the Toronto International Film Festival is of Barbadian roots, and I can think of many more. But equally, beyond that bilateral relationship, as you just said, there are a lot of things happening globally that are of concern to us, to other small island developing states, to other developing countries, not just in the climate crisis, but also in terms of how the international financial system is working for us to allow us to be able to provide for our people. And we know that your particular background also will add great value to that conversation globally. We are also happy that we can discuss matters pertaining to the climate crisis, even though there is some pausing along the way on the part of...
Okay, we got to get back to committee. Sorry, we don't have all day to listen to this. There we go.
Alors, je pense que tous nos invités sont de retour.
I think everyone's back. Go ahead, Mr. Mantle.
Thank you, Mr. Chair. I wanted to return to the idea of basic information that Ms. Gibner has brought up. I guess we're dealing with a list of identifiers, if I can use that word, for what constitutes subscriber information. Is there any categories or classes of subscriber information not currently listed in here in your mind? I guess that's an open question for either yourself, Ms. Gibner, or any of our law enforcement witnesses or officials as well. We were talking about pseudonyms and other things. Are there other classes that you've dealt with here that are not listed?
If I may, thank you for the question. The subscriber information definition is based on international standards and all the work that has gone on in the international community to describe these things. The A, B, and C paragraphs are supposed to cover the types of information that will be of use to police, and that's why they're described the way they are with the examples after, because to try to make them future-proof in terms of what other types of information, like information that may be used to identify the subject, and then giving a list of examples, identifiers that are assigned by the service provider, a list of examples, etc. So it's the idea is to try to be as comprehensive as possible.
Good. I was thinking that would be the case, that this list is comprehensive. I understand we're dealing with the BQ amendment, which is a recommendation from the Privacy Commissioner. So if this list is comprehensive, as you say, what would be the effect of defining it as such? Just defining the list.
The list, it works sort of both ways, right? Because the chapeau says means, which is usually a defined list. So the first part of A, B, and C is supposed to be what subscriber information means. So if you read each paragraph without the includings, that would be your defined list. So it's any of these sort of information that does these things. So that's how it should be read. So if you're talking about naming specific identifiers, like a closed list of specific identifiers, I think what that would do is that it wouldn't be future-proofed, and we may be back here in 5 years to amend this section again.
Okay, and I assume you're implying that you think that's a less desirable outcome, to come back to Parliament if there are changes that need to be made after this is passed or not passed, and let's assume for argument's sake that it was passed as a finite list, and then through experience, new categories emerge or new technology emerges, and you have to come back and revise it. Are you suggesting that's a less desirable outcome?
Whether it's a desirable outcome or not, that's sort of the drafting tradition that we use in the criminal code, to try to be neutral in language to explain what we want from a provision without being technology specific. That way the code doesn't have to be changed every so often.
Okay. I guess to the law enforcement colleagues, I want to, on my original question, which was, are there things that are categories or classes of identifying information that you, from your experience or your collective experience, would have dealt with or may need in the course of your duties, but that you don't see reflected here?
Well, in a short answer, I think that the categories cover most of the identifiers that I would look for. But once again, that's just with minimal revision in a few minutes here or a few seconds here.
No, that's helpful. Well, I hope it's not minimal revision. I mean, or minimal review. You've been looking at C-22 for a while now, right?
Yes, I just haven't considered it in that light where there might be something that hasn't been listed.
Fair enough. It's always harder to, show the negative or prove the negative. I take that as well. One of the I guess supporting factors that the Privacy Commissioner made in suggesting this is that to take your point about previous drafting or the tradition of drafting, Mr. Wong, was that the narrowing of subscriber information in the manner suggested by the Privacy Commissioner was actually similar to a previous proposal. It was Bill C-30 in the 41st Parliament. So I guess why, in your view, was it, I mean, maybe it's an unfair question because I don't know if you were there in 2012. Oh, you were? Okay. All right. It is a fair question. Excellent. I gave you an off-ramp and you didn't take it. Okay, this is on you then. So why was that approach the right one? Because it was proposed, but now it's not, and you're going with something different.
Thanks again for the question, and I have a good answer. That's why I didn't take the off-ramp. C-30 proposed an administrative scheme for subscriber information, so there was no requirement for judicial oversight. So it was scaled back for that reason. There were other checks and balances that were built into that legislation that was not enacted. So the decision was made, since we have to go before a judge now with a production order, and the judge has the discretion for granting the order or not for the subscriber information, that was the check and balance against that. So that's why it was expanded.
Okay, perfect. And so maybe here is an unfair question then. But so why do you think that if that's a reasonable response. If you have an administrative scheme, then it can be modified more easily than having to change the law. I think that's what you're saying.
No, the administrative scheme was a statutory scheme. It was a statutory scheme that was proposed, so it would have been difficult to change as well.
So then, I guess my question stands then. So why was that? Why was the definition of subscriber information the right approach then, but is not the right approach now?
Well, as it was an administrative scheme, so it was a statutory administrative scheme, like it was in law, but the scheme required oversight from a senior police officer. There was auditing involved, but there was no judicial oversight. There was no need to go to the court. So any police detachment could probably poll the system directly from their police department and obtain the information, and that's how that scheme worked. This scheme requires us, or the police, to go to court to get a production order for this information. So, sorry if I'm not explaining that right. Because there was no court oversight, the definition of subscriber information was scaled back. Because there's judicial oversight now, and the discretion is to the judge whether or not it's issued, that's why it was expanded.
Oh, okay, I see what you're saying. So you were more comfortable having it in an expanded manner here because of that judicial oversight. But I guess that's a slightly different question than what we were previously discussing, which is whether there may be a necessity to update a defined list in the future based on whatever changes may take place.
Right.
Okay. Thank you for those comments. I may come back to this issue, but those are my thoughts now. Thank you.
Monsieur le député Ramsey, s'il vous plaît.
Mr. Ramsey, please.
We've established that the object of this amendment was to replace a broader definition of subscriber info by a narrow list of identifiers. Now, when I look at the condition of a production order, my understanding is that not only an offense has been committed or will be or to be committed in the future, but also the subscriber information as to we need to establish that the subscriber information will assist in the investigation of the offense. Consequently, am I right to assume that a judge will not authorize the release of that info, unless the requesting party can prove it will be useful? That would be my first question.
Thank you. Yes, the affidavit has to demonstrate that all those conditions that you mentioned. In addition to that, the construction of the production order also for subscriber information also requires the police to have an identifier that the subscriber information relates to. So it's even more limited in terms of how it's constructed. So the police have to be actually seeking the subscriber information that relates to specific information already in their possession or control.
So am I right to argue that it would be probably better to leave for the judge to decide because he knows the particular of each cases, that he's more apt to decide what information should be in the production order rather than for the legislator to try to assess any cases that could happen under the sun?
That's how the production order was designed, and getting back to the previous question, because the judge has discretion to order the production of the subscriber information, we think that they're the best place to assess that based on the evidence produced by the police.
That's all. Thank you.
Merci, Monsieur le député Ramsey. Madame.
Thank you. Ms. de Bellefeuille, please. Essentially, what I understood from the Privacy Commissioner's recommendation is that since the threshold is low, he recommends that in order to protect privacy, going to get the services received may be too intrusive. So my amendment says, you talked about pseudonyms a lot, but the idea is, do we really need the services received? Do we need them listed? That's the question. Is that so essential? What's the limit to allow the police to do their job, but at the same time guarantee some protection of privacy? The fact that the threshold is low, where's the balance there? What the amendment says is an indication. It's not an order. I fail to understand, for example, that the whole issue of information obtained about services received, that to me is a fishing expedition. That's a lot. I'm wondering, if my amendment was adopted, would it really prevent the police from doing their job that much? Maybe be a little bit more difficult, but not impossible. Because once again, Mr. Wong, we're trying to strike a balance here. Right now, I feel that this is very broad, and the Commissioner told us be careful. It may be possible to obtain this information, yes, given that low threshold, but do we have to go that far? And that's what I understood from the Commissioner. Do we really need to go this far? I do know that after me there'll probably be a vote and this will be defeated, but this is what we're trying to do today. We're not trying to filibuster, we're trying to strike a balance. And I thought that the compromise that was suggested and recommended could satisfy the police while imposing some restriction and limit on the access to information such as services received by a subscriber. Thank you for the question.
I just really have a comment on that in terms of how the definition is built. Some of these categories, especially C, because the motion is asking for the abrogement, the repeal, or le biffet de C. That type of information is already available when it's considered transmission data under the transmission data production order, which is already at reasonable grounds to suspect. So some of that data is already analogous to other data that is in current production orders. So in terms of trying to be consistent in the criminal code and not having different legal standards or standards of review for the same type of data, this is why we included it here.
Ça va? Merci, Madame de Bellefeuille.
Okay, thank you, Madame de Bellefeuille. Mr. Housefather. Thank you, Mr. Chairman.
Again, introducing a whole lot of complexity to this amendment. So if I have it straight, this amendment has two parts. The first part is deleting the word pseudonym from a line of things that are including the following, which means we're essentially debating over whether or not we remove the word pseudonym from an inclusive list, which could include other things that are not enumerated in the list. Would I be right, Ms. Gibner, on that?
You have that right, sir.
Okay, and then pseudonym. Does anyone remember Carla Bernardo, Carla Homolka, the wife, girlfriend of Paul Bernardo? I believe she went by Leanne Teal, correct? Would that be a pseudonym for Carla Homolka? So if Carla Homolka, for example, had gone to the old days when you used to develop pictures, had gone to a photo store, and let's say they had this on information online or wherever they kept it in their records, but instead of using Carla Homolka to develop pictures that she took at the crime scene when these poor girls were being victimized, she used the name Leanne Teal. I assume that this intention is that maybe it would be more difficult to get the information than if she had used her real name of Carla Homolka. Would that be correct if you remove the word pseudonym?
If that question's to me, that would be my understanding, and I think that's what I heard.
It's to you until I say otherwise.
Okay.
So far, you've been very good at giving me short and clear answers. So then, the other question I'd have is, why would a pseudonym be more important to my privacy interest than my own name, my own email address, my own telephone number? It seems incredibly odd to me that we're having this whole argument about whether a pseudonym, a fake name that I intend to use, somehow gives me greater privacy rights than my actual information. Do you not find that a bit weird? I see you're nodding, so maybe you want to... Oh, no?
No, I suppose I don't, because I've worked with law enforcement for many, many years now, and as the online environment has just exploded, we all do it. I do it. I mean, I smile because I know my first email account when I was 15, I didn't use my name because I didn't want it connected with me. So anyways, just a little personal anecdote there. So
sure, like again, it seems to me that your name is more important than your pseudonym. So I don't understand that whole part. The second part of this seems to be to remove the word, the type of services provided, and the period during which the services were provided. So again, this would be, I go to this photo store with, but I won't be able to find out at this lower threshold whether or not she had photos developed. I mean, that's the whole amendment. So I'm not really understanding why either a pseudonym or the type of services I had provided or the period during which the services are provided are somehow higher privacy rights than the other enumerated parts of this section where we describe and explain what subscriber information is. So I guess my point is I'm voting no. My other point is I don't understand how this is so complex. I think I was able to boil it down into two parts in about 7 seconds. Thank you.
Merci, Madame Kirkland.
Appreciate that. I will not be daunted by the idea that asking good questions is silly. I have, Mr. Wong, you mentioned something a little while ago that I wanted to pick up on, which is why I got myself back on the list. You said something about future proofing, and I wonder if you could just be clear on that. I think that was the term you used. Correct me if I'm wrong.
That was the term that I used. And
can you clarify what you mean by that?
The convention in the criminal code is to, sorry, I hear myself in the speaker, is to use words that describe what we want it to achieve or the types of services without naming the services. One of the things that we did back in C13, which was, I don't remember which parliament, but we removed the word telegraph from one of the provisions in the criminal code because no one uses a telegraph anymore. And we replaced it with something akin to means of telecommunication, which covers any sort of mode of telecommunication. So this is what we're generally meaning when we talk about future-proofing. We use general language that actually gets to the heart of the criminal behavior and not specify the mode of how it was accomplished.
Okay, so if I'm going to be honest with you, that term is really what stops me and makes me pause. Because so how difficult was it to amend and remove the word telegraph in that example you gave?
It seems difficult for any piece of legislation that I work on, so I would say quite difficult.
Is that safe to say you're always on the difficult legislation, are you? Seems like it.
I work in the area of investigative powers, so.
I would think the safe and secure and, quite frankly, the way we protect Canadians' privacy is to do what is needed at the time. And should amendments be needed 5 years from now, then we address that at the time. I think that's why the Privacy Commissioner made these recommendations. And I have a great deal of respect for what the Privacy Commissioner has said and what he has proposed. And, I don't think Mr. Housefather meant to make it sound like he was being silly, the Privacy Commissioner, by, not getting it in terms of the recommendation, because I would find that quite offensive. But okay, let me do it this way, I'm going to ask this question, and I would love to have the answer, if you wouldn't mind, from each of you, including Mr. Nashef, if you wouldn't mind, from CSIS, as well as maybe Mr. Wong, Ms. Gibner, and perhaps Mr. Gilks. You may have input on this as well, or anyone else who feels they have input. Again, prefacing with, the job of, it feels like your job here is to explain to us why we need to provide lawful access and much more lawful access, right? We want to give access to law enforcement. That's the deal here. Our job, we have to balance that, right? We have charter rights that we have to consider and the expectation of privacy. So with that, and with the Privacy Commissioner specifically making these recommendations, I would ask each of you to tell me, why do you think the Privacy Commissioner has suggested this amendment? Why do you think it is that he has suggested this amendment? If it's so difficult and puts up such a barrier and a roadblock to lawful access? Mr. Nashef?
I wouldn't want to speculate on his specific motivations. I think what I would say is to maybe circle back to Madame de Bellefeuille's framing earlier, which I do think is helpful. I think reasonable people coming from different perspectives could try to strike the balance between privacy and security in different ways. And I think we're all trying to do that and to get it right. I think, if I might add one line from our perspective, I take her point that we're intelligence or law enforcement on this side of the table, and so we stand where we sit. We come with a specific perspective. I would say, though, at the same time that we're actually deeply motivated by striking that balance, and we might strike it in a bit of a different way, but we certainly appreciate the criticality of both ends of that. And so I think my only point is, if I was speculating on my own stuff, so maybe not on Monsieur Dufresne's perspective, I would say that I think Canadians would be quite worried if they understood the challenges that law enforcement and intelligence have in carrying out what are sort of bread and butter protection of national security and prosecution of crime in this country. And so I think what we're trying to do is modernize that in a responsible way, to be able to do that work by striking a slightly different balance that I think has gotten out of whack as legislation has been difficult to modernize, to be really frank with you. So maybe that's how I'd answer that and pass it to Norm or Rick.
Thank you. I'm not going to speculate either on Mr. Dufresne's motivations for putting forward this recommendation, but I will underline that at the Department of Justice, the laws that are introduced, and part of my job is to ensure that they comply with the Charter. So that's core to my job. Going back to what Madame de Bellefeuille said too, the objective of this bill is to provide greater lawful access. So yes, I do have an interest in this because that's what the objective of the bill is to do. There is a public outcry in this country for public safety in terms of crimes on the street and what we're seeing. Police today, what we're hearing is that they don't have the tools to properly do the job. I know that statistics were provided to this committee from the Canadian Centre for Child Protection too, in relation to how many cases get cleared. And I think that is a reflection of how difficult it is to investigate crime.
And I hear you, but can I just clarify something you said here, because it does speak to that. I believe you're here to provide information to us regarding this bill, but it almost sounds like you're admitting you're here to advocate for this bill as it's written. It sounded like that to me.
I'm sorry if that's the way that it came across. Maybe I'm too vested in this bill, having lived it for the last 3 years. So,
all right, let's move on to the others. What your thoughts are? We have to respect what the Privacy Commissioner. He has a job to do, and he has done a very good job. And if we don't balance it, I don't know how. I don't know how many more amendments we have to look at that are recommendations from him. But if this committee continues to strike down recommendations from the Privacy Commissioner, I think that we're going to be in a heap load of trouble from the Canadian public. And I think we have a duty to uphold that expectation of privacy. So that's why I'm asking this question very specifically of everyone. You know, if this was obviously important to the Privacy Commissioner, enough so that he gave us a recommendation for amendment. So that's why I'm wanting to know from you all why you think he would make that recommendation.
Thank you for that. I'm just gonna say one thing, and I think the RCMP will be able to supplement. And putting aside the conversation about how difficult or not amending legislation can be, because that can vary depending on the circumstances, and it's not really for us to say, and it's not our role to pass legislation. Part of the reason, and we talk about future proofing. The legislation or subscriber information or other parts of the legislation is worded the way it is that technology is changing fast. What might be one way today of identifying a subscriber, we had name, address, email, phone number, is relevant today and works today, but if it were an exclusive list during the course of an investigation, that might be a limit to police to identifying a suspect in a specific crime if there was an exclusive list and there were other ways of identifying the person. And so I think that can be a limiting factor in real time, because technology changes so quickly, and there are probably even things that exist today in technology that speak to identifying subscriber information that isn't listed here. And so I think there's a real on the ground impact to that, and then the RCMP can speak to that. But things evolve so quickly that even if you were doing legislation super quickly, it could have real impacts on real investigations.
Yeah, I would just add that from a law enforcement, I too am not going to speculate on as to why the Privacy Commissioner has put forward what he's put forward. But from a law enforcement perspective, I can say that we're looking for, as the bills started off saying, they were timely access to information at the beginning of an investigation where we have a crime and a victim. So I can say with assurance that there's no investigators that are looking to have evidence as part of their file or go to court and give disclosure that is not charter compliant, that is going to get the case thrown out. So from a law enforcement perspective, we're looking at the guardrails and the balances in the legislation as proposed so that we can advance investigations, because although the Privacy Commissioner has a mandate that he's speaking to, law enforcement's mandate is public protection and doing criminal investigations in a successful way for victims of crime. And the fact of the matter is, technology is an integral part to all investigations in this day and age.
Thank you. I do appreciate that. Listen, I'm what you would call a typical law and order conservative. So I completely am with you in terms of how can we make it so that you can catch the bad guys, but we still have to balance the privacy of Canadians, and we would be doing ourselves a disservice if we didn't do that. I guess what I was hoping I would hear from the witnesses here that you in terms of why you thought Mr. Dufresne would recommend these amendments is this, that his motivations are to defend the privacy rights of Canadians, because that is the answer. That's why he made the recommendations to defend the privacy rights of Canadians. So, with the permission of the committee, I really believe we need the Privacy Commissioner in our future meetings, and it would be. I don't see any reason why the committee would have anything against this. So I don't know how to present this. Perhaps it's a unanimous consent motion to ask that the Privacy Commissioner be invited to appear for the remainder of our clause-by-clause meetings?
Unfortunately, we can't submit any motion at this time. We already have one.
Can we get consent of committee to invite the Privacy Commissioner for the remainder of the clause-by-clause?
I doubt there would be unanimous consent, and it's not possible from a procedural perspective.
What about once? Point of order, Mr. Chair, just to elaborate on that, when we are no longer considering this clause, can Ms. Kirkland then move her UC motion?
No, we're moving motion after motion, as set out in the agenda.
Okay, so her motion cannot be moved at any time throughout this meeting?
Not as we proceed through clause by clause.
Sorry, may I?
Yes,
Something
please.
you said just a moment ago, I just have a question. You said you doubt we would have unanimous consent?
Well, this is a comment that was irrelevant because we don't have the opportunity to discuss other motions.
So we're not allowed to. Are you a chair? Are you allowed to invite the Privacy Commissioner to?
No. Well, I don't decide things on my own, and we currently have a motion, which is the amendment under consideration. Would you want to continue, MP Kirkland? Otherwise, we have MP Howe and MP Mantle.
Point of order, Mr. Sorry, I'm confused by your advice here. My understanding is the committee is master of its own process in all things, and so, yeah. Does the committee have a routine motion that would prevent it from doing a UC right now? Because if not, then the committee is free to consider that. I'm confused.
No, it's part of the procedures that are in the House and that we have adopted earlier in June last year. So if you want to conclude, Madam Kirkland, I'll turn to MP Howe.
Sorry, I'm not finished on that point of order, Mr. Chair. You said there was a routine motion adopted by this committee earlier on this. What motion would prevent the committee from considering a UC right now?
The business decisions, the committee business decisions that we made last June state explicitly that we move motion after motion. We have a motion now. So you may want to continue.
Oh, sorry. Explain that again. Move motion after motion?
We have a motion now. The next motion will be another amendment, and then there will be a clause motion and so on until we finish.
Motion after motion. So could I insert a motion between two motions?
We have a set of motions ongoing. We've discussed that earlier in the previous bill consideration.
Privacy Commissioner.
Okay, who is next? Because you wanted to. Sure. I have some real questions about that, and I may bring a point of order up later regarding this. Thank you.
MP Howe?
Thank you. Originally, I have questions that I want to ask later, but since some of my concerns has already been raised and discussed here, so I decided to ask some of these questions. And one thing that I've been struggling so far is that how do we delineate grounds to believe and grounds to suspect? And, how do we, distinguish when would it begin and stop? So that has been my struggle all the time. And I'm also grateful that Sergeant Gilst, you use concrete examples. I think this is what I need because I'm a concrete sequential learner. So I need stories, facts, and examples to help me understand. Now, early on, you gave a very good example saying that somebody discovered that his bicycle was being stolen, and then you say, hey, all the things, all the descriptions are pointing at one person, and then there's reasonable ground to suspect, right, and have the guy investigated. Now, let me give you one real case in Richmond, which happened many years ago, and see, how would the core suspect would fit into your description or classification. There's a resident in my riding, in my neighborhood, actually. He was a gardener. He spent lots of time doing gardening, and he has a beautiful garden. So one day, he discovered that his garden was being destroyed. So he made a report to the police, and he said that it could be or is likely to be my neighbor. For the reason that, number one, he said that he didn't like my garden. He hates me for doing the gardening because each time when I'm doing the gardening, he would come to the fence and yell at me. He said that I didn't understand what he's talking about, but when I stop, rise, and go back to my house, then the person would be quiet. And not only that, he said that I receive phone calls in the middle of the night. When I pick up, somebody talk or yell, in a very loud voice in a different language, which I don't understand. And then he hang up. Now, in that kind of situation, how would you classify the neighbor who's living next door? Is there reasonable ground to suspect or reasonable grounds to believe?
Thank you for your question, Mr. Chair. So I suppose it's a very specific question, and that would, I guess, depend on the frame of mind or my frame of mind at that time. The thing is, it becomes almost moot because it's going to be up to the judge or justice to decide at that point whether that's a grounds to suspect or grounds. I mean, if we're going for subscriber information. In terms of whether that would be grounds for confirmation, because based on what has been described, do we believe that there is an offense that has been committed? Well, I mean, I do. If based on what you've explained, there is a possibility that a crime has been committed. So if that is the case, then information that I obtain based on questioning, or I'm not sure who I would place that question to be honest, if it was a confirmation of service. But in that case, if I believed that the information that was provided to me could further my investigation, well, then that would be a good example of something that would be at a threshold of potential.
Yeah, I'm asking a simple question. So in a case like that, from the perspective of the police or investigator, is it believe or suspect?
Well, it's entirely up to the investigator themselves. So they have to take whatever circumstances that they actually have and come to their own determination on whether this is something that they believe has been an offense or that it has not been. And that could be from visiting the property, from seeing the type of damage that has been done. The intention is always to corroborate. So police cannot necessarily advance an investigation without trying to corroborate whatever information has already been received or whatever information they are receiving. So it would be really up to that investigator to take the steps necessary to try to corroborate whatever statement they're receiving from a victim or a potential victim.
Well, it's more confusing now. You seem to imply that this is subjective. depending on the interpretation of the investigator.
This is accurate. It's not. It is subjective. It is subjective, and it depends on the I guess the vehicle that is being adopted. So it's objective for the police officer to decide if it's a confirmation of service. It's up to them to decide whether they have the reasonable grounds to suspect. If they're going for a subscriber information production order, in that case, it'll be up to someone member of the judiciary to decide whether they've reached that threshold that would be necessary. Same thing for reasonable grounds to believe. It depends on. It really is subjective because these are people who are making a decision on whether something has reached that threshold or not.
Well, again, I find this very interesting. So when we are going to create a law or legislation, is it not our goal or our objective to try to eliminate the subjectivity of interpretation?
Well, I won't speak to the objective of the laws themselves, but these are concepts that are already well ingrained in the criminal code that police work off of and have worked off of for many years.
This subject is quite subjective. Okay, now let me tell you what exactly happened. And that's why I'm so worried that, if we adopt if we are not clear about the distinction of definitions, we can create problems. What actually happened was this person's neighbor is a chiropractor. So when he saw his neighbor kneeling down to work on the ground, he was concerned. So that's why he came to the fence and yelled at the person, say, come on, get up, it hurts your back, and things like that. So when that person went back to the house, he was so happy, right? And later, it was discovered that the phone calls that this person received at night was an overseas call, an international call from another country. And because of difference in time zone, so he received a call at night when the person who was mistakenly, wrong number, right, make the wrong phone call, was the daytime. So I think all these things could be reasonable. All these things could be misunderstood. So that's why I'm so concerned about without a better word, the failure to make a clear definition. Now, let me ask you another concrete example. Again, you receive a call or a complaint saying that, okay, there's something happened, and the person gives you a description of 5 features of the suspect, 5 things. And then the police was able to locate a person that fits all the 5 features. So, is it ground to believe or ground to suspect that person is involved?
Oh, sorry.
Just on that question, what I would say is to not oversimplify the process is that the investigator, I think what Sergeant Gilks was getting at is the investigator has to do a lot of work in behind getting to his determination that he feels he's met a reasonable grounds to suspect to the point where he can draft an affidavit and go before a judge. So the subjectivity is not that, on the face of it, it's a subjective decision to say that's your suspect. What he's saying is, I've interviewed people in the neighborhood, I've done all my follow-up, I've done a whole bunch of investigational work to get to a point where I feel there's potential that this crime occurred and I need more information. That's the suspect. But the investigator doesn't get to decide that that's the case. The judge gets to decide whether that constellation of facts that's been presented in the affidavit meets what he feels or she feels is reasonable grounds to suspect and grants the production order for a specific kind of information. So I think just to clarify the subjectivity of it is any investigator in any police force, not just in Canada, has to get to a point where they've done enough work to determine that they feel they have something to go to court with, suspect or believe.
Now, but in this case, what the government is trying to seek is the power not to involve the judge. You want the power to have to, to get information of that person faster, easier, and without any kind of check. Is that not the case? The judge is not involved in the example that I gave.
No, that's not the case. For a production order for subscriber information, there needs to be an affidavit, and you have to go before a justice or a judge for them to determine whether you've provided enough facts to get that production order at the beginning of an investigation where you're trying to determine, you've figured out there's a crime, now you're trying to link that crime to someone. So it's not subjective and it's not without process.
No, are you not trying to get, lawful access to the information of the people that you have reason to suspect?
Exactly.
Exactly, right? So the judge was not involved.
No, the production order is for a smaller group of identifiers. It's the beginning of the investigation. You're trying to get a simpler set of information, as opposed to a general production order where you need a much higher threshold and you get access to a bunch of information, some of which you probably don't need. So again, going back to the timely access for law enforcement at the beginning of an investigation, that's what the tools are. But it's not just without process.
My question is actually how wide the net you're going to open in the beginning?
I think, and I'll ask my colleagues from Justice to articulate perhaps, but I think the purpose of these tools is to narrow that scope at the beginning to start your investigation.
This is what I'm trying to get at. So I want to see how wide or narrow the net is going to be in the beginning of the process. I understand that, when there's further investigation in the process, there are more, hurdles, so to speak, right? But what I am worried about is the beginning. So just like to continue with my example, the person fits 5 features. So does it fit reasonable to believe or to suspect?
I would say that's impossible to say without being involved in the investigation, because I haven't questioned anyone. I'm not part of. I don't know what the facts surrounding those 5 attributes are. I'd have to do some investigation to decide.
Pick it up, right? Age, gender, color, outfit.
I couldn't speculate on unlimited information.
So, let me go on. Okay, this I'm using this example to try to understand. So I would assume that if this person fits all the 5 descriptions,
understand.
You would say, not you, but it's reasonable to say he is a suspect. Not necessarily, but reasonable ground to believe that he was the guy, right? Reasonable ground to believe. But if it's down to 4, down to 3, down to 2, down to 1, then I would say that perhaps, when it is down to 1, he would be classified as, reasonable to suspect, right? 5, say suspect, 1, ground to, 5, ground to believe, 1 is ground to suspect.
Oh my God.
Would that be reasonable?
Again, you'd have to prepare an affidavit with facts for a judge around that one attribute. Very difficult to say in the hypothetical.
Well, this is not hypothetical. That could happen.
Yes, you are. You are
in real life.
hypothetical right now, man. I'm not going to lie. You're losing me.
What I'm trying to ask for is, how do you think draw the line? Because again, it can open up a big net that can almost catch anybody with the most limited feature that will fit a description. How can we avoid that kind of situation from coming up? That you investigate somebody just based on the most basic, limited information.
We go back to the police still have to do work behind the information, even if it's basic, to be able to prove to a justice that they have enough to get more information. So from the example you're giving, I appreciate what you're trying to say is that you're saying a subjective decision and a whole net of information could be gathered based on one factor. And what I'm saying is I don't think that would be reality from a policing perspective, because I have to go before a justice with an affidavit laying out facts saying why I believe I should be entitled to this charter, compliant information. So there are guardrails and checks and balances in the way that we're getting a narrow bit of information at the very beginning, at the very outset of a criminal investigation. So given your example, I couldn't say what you could build as an investigator around one attribute.
Okay, good, fine. I just want to say that I share Madam De Belfeur's concern. Whether or not you're going for a fishing expedition. Okay, I want to ask you another question. Again, my colleague MP Mantle asked a question about the definition of. He asked you a question about how the difference between including and why not you use the word including, which opens up the net again. So my question is, why not instead of use the word including, which opens up the net, you use the word limited to? Because you are talking about you want some concrete information, the name, the address, or a few things. So why don't you list those concrete things that you think you need and use the word limited to instead of including these things and then open up the net?
Thank you for the question. As I mentioned before, the definition of subscriber information is modeled on international definitions of the same information. The way that it's been constructed is that if you limit those things that are supposed to be examples of the types of information that are listed in paragraphs A, B, and C, you'd have to rewrite the definition to make sure you didn't forget elements that are obvious that fit under there. So, for example, like the identifying information, the name and address you'd want there, but you may want other identifiers. So in terms of what's currently before the committee right now, I think if that suggestion were to take root, the definition would have to be recast and redrafted to make sure that all of the obvious identifiers in those classes were listed. So it would look completely different than it is now.
Okay. And then, again, my final question is, now, all along, I was given the impression that the information that you are seeking are just primary information, limited, and being categorized as if they are insignificant. They are not big. It's not a big deal to have that kind of information. I mean, if they're so insignificant, so why would you need a law to compel the companies to give you this information? It's not voluntary. You compel them to do it.
Thanks again for the question. I think that's a good policy question in terms of the mechanism. Prior to 2014, most of this information was available to police without a warrant because it was seen as being so low threshold. Since the Supreme Court of Canada decision in Spencer, there's been a lot more privacy interest attached to subscriber information, and police have had to use a judicial order to get it because there was nothing else. Mr. Mantle before mentioned Bill C-30. That was a government attempt at codifying a scheme to obtain subscriber information under administrative scheme. So there have been many attempts by various governments to do this. But you make a good point. The decision by the government was to choose a judicial order for this because they thought it would be probably the least path of least resistance because previous governments have tried an administrative scheme for this and it didn't work.
Good. So, Mr. Chair, those are the questions for now.
Thank you, MPR. We have MP Mantle and MP Kirkland.
Sorry, actually, can I just come back to my point of order is what I will. Is that okay? Point of order? Yes. Sorry, I was getting sleepy. Good questions though from my colleague. I think we had three final questions. But no, my point of order. I just want to come back to to the benefit of the chair. I wasn't moving a motion earlier, so I just wanted to make that clarification. I was simply requesting unanimous consent, which is not debatable and votable. I understand that, but I do also understand that it's not really up to the chair to deny consent. It's up to the committee members to deny consent. So I would like to request consent that from this committee that we invite the privacy commissioner. I do have a reason for that. When I asked the question, the folks on this panel were not able to tell me why they thought. I mean, we're wondering why the privacy commissioner made recommendations, but he's not here to tell us why, and none of us can articulate why. We have members, who are here trying to explain to us, how the how this bill is going to be good for us. I just for the balance, I'm requesting the committee to give unanimous consent to have the privacy commissioner join us for the rest of clause by clause after this meeting.
Good. So let's see whether there is unanimous consent to moving and adopting this motion.
Can we adjourn for 2 minutes?
Suspend.
Suspend. We'll suspend for 2 minutes. So I have the clock in front of me, so let's do that for 2 minutes.
Interesting, Duclos, because you said 2 minutes, not 2 minutes ago, but 20 minutes ago, you said that you couldn't do that it was out of order. And it wasn't out of order. You were just an idiot and trying to be a dick, and you knew it was in order. Interesting. Let me see. Is there anything else we can tune into while we wait 2 minutes? Guess we can see what the House is doing.
And the unions themselves have put the money aside to build these facilities. Yes, now in certain provinces, they're getting provincial money to help with that. And at the federal level, there has been programs to do that. In fact, in the last election, the Conservative platform included a massive increase in funding for the UTIP program, and including elements like a bricks and mortar thing to help expand union training centers. So I know how hard our unionized construction workers work in this country, and they deserve the best representation. I agree with that unequivocally. So when I look at this member's piece of legislation, I break it down into 3 categories. So the first category is the definition in the Canada Labour Code, which currently says "so dominated," which I've always thought was a bit of an odd term. You're either dominated or you're not. What does "so dominated" mean? Like, it's okay if you're a little dominated? So look, I think the member's right. The Canada Labour Code should be changed. We should remove "so dominated." That modifier, I think, adds a level of domination when no domination should be acceptable. The test should be whether or not a union is dominated by the employer. So I give the member kudos for identifying that. And
is there unanimous consent to table this motion and adopt it? No? So we'll continue then.
Okay, so they didn't get what you see. That's exactly what was
Mr.
going to
Mantle,
happen
it's your
anyway.
turn.
Thanks very much, Mr. Chair. I thought that was a pretty reasonable request. Unfortunately, to see all the Liberal members say no at the same time is pretty disappointing. We're specifically, make faces, Mr. Arndt, about an important bill about lawful access. That's great. I'm glad you're taking this very seriously.
Okay, Mr. Mantle.
She just
no,
did.
I have to interrupt you, please. This. Okay. Thank you. Otherwise,
I'm not tired and irritated at all.
Mr. Mantle and everyone around the room, please.
She can speak for herself.
Okay. I'm going to suspend.
Oh, things are getting heated. Oh, man. Okay, well, at this point, I got to call it because I wanted to call it 21 minutes ago, but I just wanted to see where that was going to go. Oh, wait. Okay, hold on. We'll see what they got to say. They only
Thank
got
you,
9
Mr.
minutes
Chair.
left anyway. in their time.
I would move that we suspend consideration of this clause until the Privacy Commissioner can be invited to attend.
Well, this is a dilatory motion, which we're going to vote on immediately. So the motion is to adjourn this debate. Anyone in favor of that?
I said to state the clause, not to adjourn. So it's not a dilatory motion.
Stay the clause.
Stay the clause until we can invite the Privacy Commissioner to attend.
Okay, so sorry, I misunderstood what you said. So is there a motion to stay the clause, which means in practice that we would put the consideration of this clause or this motion on the BQ3 later in the process, but it can't be. We'll have to suspend because we can't do that for any particular amendment. So we'll have to check with the legislative clerk whether this is possible.
He's suspending again. Oh, Lord. Yeah, I do really got to go, though. I can't keep this up. It is getting a bit spicy, but unfortunately, it just kind of... Whoa. Hold on, what just happened? Well, my output just went way down. What the hell? Okay, there we go. We're back. My OBS has been doing this recently where it just decides to go from like 10,000 KBS to like 800. And I don't know why it's doing that. But anyway, yeah, I'm going to have to leave it here. I can't... I wanted to call this 23 minutes ago, so I'm just going to have to call it here. And I will see you guys on Monday. I haven't checked to see what's on for Monday, but let's see. I don't think they have any already pre-scheduled meetings. Oh, there is stuff on Monday already. Hold on, we'll listen to this for a sec.
On recommence donc la motion est...
Okay. The motion is to set aside discussion on Clause 4 to later on in the clause-by-clause consideration. Is this motion adopted?
N'est pas adopté, Monsieur.
It is not adopted. Mr. Mantle, you have the floor.
Thank you. I guess this is a point of order, though. Your description of what my request was not accurate. It was conditional. It wasn't simply to delay consideration of the clause. It was to delay consideration of the clause until the Privacy Commissioner can be present for that. So...
The motion was defeated. We can revote the motion again.
Okay, then I'd like a recorded vote.
Okay, donc Monsieur le député Mantle, vous voulez déposer.
Mr. Mantle wanted to table a motion to reserve consideration of this clause later until such time as the Privacy Commissioner can be invited. So we'll proceed immediately with the recorded division. Is this motion adopted? There is a request for a recorded division. Mr. Clerk, please go ahead with the recorded division.
Thank you, Mr. Chair. The motion is to stay Clause 4. Monsieur Jacques.
No. The absorb.
Mr. Hessfather.
No.
Ms. Akan.
No.
Madame Dandurand.
No.
Ms. Sodi.
No.
Mr. Francescatos.
No.
Mr. Caputo.
So yes.
Ms. Kirkland.
Yes.
Mr. Au.
Yes.
Mr. Mantle.
Yes.
Madame de Bellefeuille.
Yeas pour 5, nays contre 6.
Merci, Monsieur le greffier, de ce bon.
Thank you for that great calculation, Mr. Clerk. So the motion is defeated. Mr. Mantle, do you have anything else to add?
Yeah, I believe I'm on the speaking list next. Yes. Okay. Thank you, Mr. Chair. Returning to BQ2.
Okay. Yeah, at this point, I am going to call it. So I will see you guys Monday. It doesn't look like we've got anything on in the morning, but, I mean, there's still committees that are going to be scheduled over the weekend, so I'll wait to check up on that. But for sure, we're going to have question period 2 p.m. Eastern Standard Time on Monday. So I will see you guys then, and have a good weekend, everybody. Thanks for tuning in and watching. Have a great rest of your evening as well. Bye, guys.